Hi, my name is Jonathan Roven. I am an employment and personal injury attorney, and today I'm going to be discussing deposition preparation, how to best prepare for your deposition so you give an absolute best deposition in your lawsuit. So the first thing is that you really want to get a good preparation the day beforehand. So if there's information regarding your case, if you answered discovery, responded to some discovery, if you gave a deposition before or any statements before, you're going to want to review those and see that your testimony is going to be the same as anything that you said previously. Otherwise, the other side can look and find inconsistencies and try and see if you made some issues or wrongful statements previously. So after that, you'll get a good night's sleep, eat a good breakfast, and the next day you'll show up for your deposition. A deposition is an information gathering session where what you say carries the same force and effect as if you're testifying in court, even though it's an informal proceeding, whether it's in a conference room or by Zoom nowadays or online by video conference. There's a court reporter present which will transcribe everything that's written, as well as the opposing counsel, the opposing attorney that will be asking the questions, and if you're represented by an attorney, then your own attorney who can insert objections. And so at the very beginning of the deposition, they will go over what's called admonitions or warnings. Kind of like the ground rules. So admonitions would be things like not speaking at the same time as the attorney because there's a court reporter writing down everything that they're saying. So if two people are speaking at once, then the court reporter cannot write down everything that's being said. Another one in that same line is that you need to provide verbal, audible responses. So a shrug of the shoulders or a nod of the head cannot be transcribed by the court reporter. So you're going to want to answer questions. Yes, no, I don't know, etc. Another one is that at the end of a deposition, you'll have an opportunity to make changes to the transcript, but any material changes could reflect poorly on one's credibility. So you don't want to change a yes answer to a no answer, green light to red light, etc. Another one is that you want to not speak over the attorney. You don't want to make it very difficult for the court reporter, as we previously reviewed, and you don't want to speculate. So an attorney or the opposing party is entitled to a best estimate. If it has to do with the car accident case, what's your best estimate as to how fast a car was going? What's your best estimate as to time, speed, distance? But they don't want you to speculate or guess. So if you don't have any sort of basis of knowing, you don't have any personal knowledge, like you weren't there, then you wouldn't be giving an answer, because that would be speculating, or you would just say, I don't know. Or for an employment situation, if it's asked who was at a meeting and you weren't there at a certain meeting, then you obviously wouldn't know who was at the meeting because you weren't there. So those are the basic admonitions. Just a couple different ones that the opposing party won't go over is you don't want to be talking too much. You don't want to ramble on and just give answers, long-winded answers. It goes for multiple pages on the transcript. A lot of times those can be picked apart and turned against you. Another one is that you don't want to just be a robot and just say yes, no, I don't know, because this is an opportunity for the opposing party or the opposing attorney to get a sense of the kind of person that you are, and if it's a jury trial or a judge trial or arbitration, then how you're going to come off to a fact finder. And so during the deposition, the opposing party is going to ask various questions, and your attorney, if you're represented, will have an opportunity to give certain objections. So at a deposition, You object to the form of a question. So, for example, some examples are objection, it's vague, objection calls for speculation, objection calls for legal conclusion, things of that nature. So a vague objection means that the question may be unintelligible. So if it is in fact vague, like vague as to time, saying, if they said, when did you go to the market? What day? When did you go to work? Well, what day? So that might be a vague question. What time period are you referring to? So you may want to ask them to rephrase if you don't understand the question. Calls for legal conclusion. That's typically where an opposing party will insert a legal term into a deposition. For example, they say, what facts do you have to support your cause of action for negligence? And someone who hasn't studied law or gone to law school or is not an attorney might not have any idea how to answer a question like that. So that would be an objection calls for legal conclusion, because a person's not going to know how to break that down or answer it, or what the facts are that are necessary to support that. That's a very lawyerly question, and so that your attorney will probably object, saying calls for legal conclusion. And if you don't understand it, then you may want to ask them to rephrase. What do you mean by negligence? If you don't exactly understand it. Another one is that it calls for speculation, as we were discussing before. They say, what if a question's asked, what did the human resources director think about your performance? Unless they said to you specifically, I'm loving your performance, or I'm hating your performance, or you heard that they love or hate your performance, you're not going to know. Did they even see your performance? We don't know. Another example is, where was the opposing party driving to at this time? Well, unless they told you, you're not going to know. So it would be calling for speculation. Or how many times did a coworker complain about this or that? You're not going to know unless you were there for each and every complaint, but you'll know the times that they told you about or that you heard about. So those would be questions that would be calling for speculation. So that's a general overview of what a deposition is. Typically in personal injury and employment cases, you're going to want to have reviewed your prior discovery responses. You're going to want to have reviewed any medical records that you may have had, so that you could see what statements you've made to doctors, and which types of doctors you've been to and when you've been there. So those are pretty important to do. You want to review a chronology of events so that you kind of can give a basic timeline as to your incident or your harassment or termination and what had occurred before and after. And this is the big opportunity to solidify your timeline and your testimony. And if the case goes to trial, it most likely, the transcript most likely will be referred to at the time of trial. So it's very important to give accurate and adequate testimony at the time of trial. I hope this is helpful. If you guys have questions, please ask, and good luck at your deposition.